Parliament has agreed that it should not prejudge Mr S Iswaran's situation, but rather it should wait till the outcome of the investigation. Mr Iswaran is currently on a leave of absence while under a corruption probe. MPs had voted against suspending him from Parliament, a motion moved by the Progress Singapore Party. Well, he is receiving a reduced monthly pay of $8,500 in addition to his MP allowance. The government says it will consider clawing back the salaries paid to Mr Iswaran if he's charged.
We will consider a clawback if justified. If he is charged, the Prime Minister will consider the allegations, the accusations against him and decide whether to make him resign and to pay back both salary and allowance without waiting for legal process. Now, bear in mind, this is a party discipline matter.
A non-constituency MP Hazel Phua of the PSP had moved the motion, arguing that MPs under investigation for graft should be put on no-pay leave until the case is concluded. And this is especially so given Singapore's zero tolerance towards corruption.
Should we have a system that allows an outcome whereby an MP who is eventually found guilty of corruption and whose duties had been suspended can continue to receive in full his or her MP allowance over the entire duration of investigation, plus the duration of court proceedings until he or she is finally pronounced guilty and all avenues of appeal exhausted? This motion is therefore about the prudent use of taxpayers' money, not a presumption of guilt.
But MPs disagreed, stressing that a fundamental principle of law is that a person is innocent until proven guilty. Leader of the opposition, Pritam Singh, also warned that the motion might set a precedent. All 8 opposition MPs from the Workers' Party voted in favour of the government's motion and against the PSP.
With respect, I would also request PSP colleagues in the House to consider the precedent their motion would create should a future government decide to fix opposition MPs by way of politically motivated investigations. In the Workers' Party's view, the wheels of justice must be allowed to fully turn before Parliament decides what to do. The Workers' Party cannot agree to the motion filed by the PSP.
As it stands, Mr Iswaran is still under investigation. No charges have been brought at this point, and no determination has been made by a court. Therefore, the presumption of innocence continues to stand unrebutted.
Well, the issue of how the motion seems to only target one person was then raised.
Why would PSP want Parliament to amend an Act of Parliament just simply to push for the suspension of salary of one particular MP?
Generally, legislation is meant to address the country at large and is not meant to be targeted at an individual or a particular case. It would actually be quite unprincipled to amend legislation for a single case.
Ms Indrani also asked Ms Phua what are the kinds of offences which would constitute a suspension apart from corruption, as there are also MPs who are currently under investigation.
At the moment, there are 3 members of Parliament under investigation: Mr Iswaran, Mr Pritam Singh and Mr Faisal Manap. Regarding Mr Singh and Mr Manap, members will recall that this House had referred Mr Singh and Mr Manap to the public prosecutor following the outcome of the Committee of Privileges inquiry into the complaint against Ms Raisa Khan. Notwithstanding that they are under investigation, they have not been suspended. Because Ms Phua has limited it quite carefully to corruption, can I ask Ms Phua, is it her view then that if an MP is under investigation for murder or for rape, then suspension should not apply?
I have not thought about those other cases. It is not my intention to set out the rules under which members can be suspended. I am merely looking at a case in point where I feel there is a strong case for suspension.
Then in her final address, Ms Indrani revisited the topic of whether the PSP considered other offences for possible suspension.
But then I asked Ms Phua, what about rape? What about murder? If a member is under investigation for those offences, should the member be suspended? Ms. Paul did not have an answer. She said she had not thought about that, which means that she had not thought about the principle. Now, this is worrying because it means that when PSP advocates something, they're not acting as a matter of principle, but as a matter of targeting a specific individual. And that is my concern.